we submit that the plaintiff bears the onus to prove all factors on the balance of probabilities that the defendant breached his duty of care. One factor is that the defendant knew or would reasonably have known that the risk of injury was foreseeable and that harm may result. The actual events as they happened are not the circumstances to which consideration of foreseeability of risk of injury is applied. What is considered is foresight in more general terms of inquiry. This was outlined in the case of Doubleday v. Kelly, 2005, where the standard of duty of care in that circumstances was just simply not met, as risk was reasonably foreseeable. Compared to the current circumstances, we submit that it differs on the basis that it was not reasonably foreseeable that the defendant could have known or ought to have known that the plaintiff was returning or had returned to the premises. The cleaner, Jack Rizzoli, unlocked the doors, which allowed for the unexpected act of Richard and Lena knocking over the plaintiff in a panicked run. The question is whether a reasonable person at the time of allowing Richard and Lena to re-enter the premises should have foreseen risk of harm to the plaintiff. And we submit, Your Honour, that to extend that duty of care would be unfair and unreasonable to the defendant. Furthermore, there is no duty to protect persons on its land from unpredictable criminal behaviour of strangers, even when the risk of harm is reasonably foreseeable, as long as a special relationship does not exist. This was outlined in the case of Mowbray Triangle Shopping Centre v. Ansell, 2000, where an employee made a claim that the occupier of the land failed to meet their duty of care by leaving the lights on in the parking lot. As a result, he was harmed. The High Court held that leaving the lights on would not have deterred the criminals, as they left the house with bats with a clear intent to cause harm, and the scope of liability did not extend to the occupier needing to leave the lights on. We submit that the defendant's actions or omissions did not cause the plaintiff, nor was the harm within the scope of liability of the defendant. The defendant allowing Richard and Lena to re-enter is not a necessary condition of harm occurring, nor is the decision to provide security. We submit that the court would not deem it appropriate that the scope of liability of the defendant would extend to the harm that was suffered by the plaintiff in these circumstances. Unlike the case of Atlas v. Tab Limited, 2005, our client did not have a duty of care in this instance. Under the common law but-for test, it would be argued that but for the defendant's actions of allowing Richard and Lena to re-enter the premises, the plaintiff would not have suffered harm. However, it might be also argued that having Richard and Lena be locked out when the plaintiff returned could have also resulted in harm. In the case of Adil's Palace v. Mubarak, 2000, lack of security was not a necessary condition of the shooting. The shooting would have happened in any case, even with security present. Just like the plaintiff would have been run into, even if there was security on the White House delegate season. It is further submitted in Adil's Palace v. Mubarak, recognizing that any change of the circumstances in which the incident occurred might have made a difference does not prove factual causation. The risk of injury to the plaintiff in this case was caused by unpredictable conduct of a third party, as opposed to circumstances where the risk of harm was directly caused by the defendant's actions. The risk of harm in the future could be minimized by refusing customers who had been drinking. However, this would not be practical, as a reasonable person can assume that this would mean that they would lose significant business based on their location. Even if security were on duty, the plaintiff may not have avoided injuries. In conclusion, Your Honour, it is respectfully submitted that the defendant in all circumstances is not liable, in negligence for the injuries suffered by the plaintiff, and an order in terms of the draft order to be submitted is respectfully sought. Thank you.